In this video, we're going to be looking at the case of Cavendish and Makdessi, a contract law case that deals with penalty clauses. The key point to take away from this case is that it establishes a new test for determining whether a provision in a contract is an unenforceable penalty clause. The facts of this case are as follows. Parking I, the claimant, managed a car for the landowners of a retail park. Numerous notices stated that failure to comply with the 2-hour parking limit would result in a parking charge of £85. When they were sued for that charge, Beavis, the defendant, argued that it was unenforceable as a penalty. The Supreme Court held that the charge, in fact, did not constitute a penalty. It was said by the Supreme Court that the true test is whether the impugned provision is a secondary obligation which imposes a detriment on the contract breaker out of all proportion to any legitimate interest of the innocent party in the enforcement of the primary obligation. A clause should not be enforceable if it is unconscionable or extravagant. Furthermore, a party has a legitimate interest in the performance or in some appropriate alternative to performance and not punishment of the defendant. Let's see how this test applied to the factual scenario. The claimant here had a legitimate interest in charging motorists which extended beyond the recovery of any loss. There was a legitimate interest in both the claimant and the landowner of the car park in ensuring the availability of parking spaces. A reasonable motorist would have agreed to the clause if they had freely negotiated with the claimant. And also, the charges underpinned the business model of free parking for 2 hours, and all of these considerations led to the conclusion that the clause, in other words, the £85 parking charge, was not considered to be an unenforceable penalty clause. If you found this video helpful and want to receive more case summaries, please subscribe and hit the notification bell.